The Supreme Court just ruled that Colorado's 2019 ban on conversion therapy for LGBTQ youth under the age of 18 violated the First Amendment. I'm going to give you the short version of it, but first, I want to be clear about something. The research on conversion therapy indicates that it is severely psychologically harmful. I've read a great deal of this literature, and anyone with solid training in research methods and psychometric skills should understand that this is not just an ideological conclusion. Frankly, those who claim conversion therapy works are often as ideologically fixed as those who claim gender-affirming care has a strong evidentiary basis. Anyway, about this ruling. A counselor named Childs filed a case with the Supreme Court claiming that Colorado's ban on conversion therapy infringed on her First Amendment rights as a therapist. Her argument was that breaching the ban could jeopardize her counseling license. Now, remember, this was a state government ban, not merely a certification board violation. So, the law made it professional misconduct for a licensed mental health provider to engage in conversion therapy with a client under 18. And it defined conversion therapy as any practice or treatment that attempts or purports to change an individual's sexual orientation or gender identity, including efforts to change behaviors or gender expression or to reduce same-sex attraction or feelings. At the same time, the law specified what was allowed, that being acceptance, support, and understanding of identity exploration and development, so long as the counseling did not seek to change sexual orientation or gender identity. It also explicitly allowed assistance to a person's undergoing gender transition. So this was not simply about coercion of minors or harmful methods in a neutral sense. It could be interpreted and was interpreted this way. A counselor may speak in an affirming direction, but not in a change-oriented one. So this becomes an issue of favoring one viewpoint over another, and that is where the First Amendment issue comes in. Yes, states have the power to regulate professions. They may set ethical standards and punish fraud, abuse, malpractice, and coercive conduct, but once the government allows one viewpoint in the counseling room while prohibiting another, it is no longer merely regulating conduct. It is regulating speech based on viewpoint. The double standard is clear. The state privileged gender-affirming care while penalizing dissent. The irony is that, in the name of preventing coercion, it chilled dissenting speech through licensure penalties. Frankly, both conversion therapy and gender-affirming care are ideological distortions of what therapy ought to be. One attempts to take something away, the other attempts to fix something in place. Neither is grounded in genuine therapeutic exploration, discovery, or restraint. But the deeper problem is that trans issues have been conflated with gay rights issues, and that conflation has weakened the rights-based framework that helped gays and lesbians secure real civil progress.